Okay, thank you all for coming. I'm going to go ahead and get started, but keep grabbing pizza or whatever you need to do. My name is Jim Spangler, and I'm a 3L and the Vice President of the Student Chapter of the American Constitution Society. I would like to thank all of you for coming, and I'd like to thank the Office of Career and Professional Development for co-sponsoring this. And of course, I'd like to thank all of our panelists for making long drives and agreeing to be here. The theme of our chapter of the ACS this semester is the 50th anniversary of Gideon versus Wainwright. And I'd like to mention a couple of upcoming events on that topic. This Thursday, we're having a book signing and lecture with Kaarin Lueck, who wrote a book called Chasing Gideon, The Elusive Quest for Poor People's Justice. Some books I think are available maybe, and the book signing starts at 11:30. The lecture starts at noon. And on Thursday, November 21st, David Carroll of the Sixth Amendment Center will join Professor Norm Lefstein of IU McKinney School of Law and our own Professor Joseph Hoffman to have a Gideon panel as well. So before I introduce the panelists, I'd like to briefly introduce you to Clarence Earl Gideon and his monumental case, Gideon versus Wainwright. In 1961, Clarence Earl Gideon was charged in the burglary of a pool hall, a crime which he did not commit. He couldn't afford an attorney, and his request that an attorney be appointed for him was denied. So he was forced to defend himself at trial, where he was convicted and given a 5-year prison sentence. From prison, Gideon filed a handwritten habeas corpus petition to the Florida Supreme Court, claiming that his Sixth Amendment right to counsel had been violated. The court denied the petition based on then-existing U.S. Supreme Court precedent, which only required states to appoint counsel in capital cases. However, Gideon appealed to the U.S. Supreme Court, which granted his appeal. And in its ruling in Gideon versus Wainwright, the court held that under the 6th and 14th Amendments, indigent defendants are entitled to counsel for all felony cases. Justice Black wrote, quote, "Any person hauled into court who is too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided for him. This seems to us to be an obvious truth," end quote. Gideon was retried 5 months later, this time with appointed representation. His lawyer completely discredited the state's main witness, and the jury acquitted Gideon after an hour of deliberation. Today, Gideon versus Wainwright is widely held as a victory for justice and a ruling that gave true meaning to the Sixth Amendment right to counsel. However, 50 years later, this country has arguably fallen short of what is required of it under Gideon versus Wainwright and the 6th and 14th Amendments. For example, according to the Department of Justice, 3/4 of the public defender's offices in this country have caseloads that exceed maximum caseload standards. In some jurisdictions, public defenders have so many cases that they may have as little as 1 hour per client, and the vast majority of criminal convictions end in plea bargains, often without any investigation into the guilt or innocence of the defendant. In many ways, our criminal justice system is one in which most of the power lies in the hands of prosecutors, and many decisions are made for the sake of efficiency rather than justice. Today, our expert panel will discuss the state of public defense in Indiana and nationally. What is the reality for an indigent defendant in places like Wayne County, Putnam County, or Lawrence County, Indiana? What about for a defendant seeking post-conviction relief? And what is the state of Gideon 50 years later, and is the Sixth Amendment right to counsel actually in force? These are a few of the questions we'll try to talk about. I'm about to introduce the panel, but I would like to ask all of you, please do not leave until 12:55. I will make sure to let you go then. It's very disruptive when everyone is leaving one at a time. Thank you. So, please allow me to introduce our panelists and tell you a bit about each of their extensive experiences working in indigent defense. Ms. Lueck is a graduate of the IU Maurer School of Law, and she works as a full-time public defender in Wayne County, Indiana, where she is assigned to criminal, juvenile delinquency, child in need of services, and termination of parental rights cases. She has presented at continuing legal education seminars about juvenile delinquency, child in need of services, and termination of parental rights issues in Indiana and for the National Juvenile Defender Center. She has also taught juvenile justice at Indiana University East and guest lectured here at the Maurer School of Law. Ms. Lueck has authored a number of important manuals for the Indiana Public Defender Council, and since 2009, she has been active in policy advocacy concerning juvenile delinquency and mental illness. including advocating for the rule for early appointment of counsel in juvenile delinquency cases that is currently awaiting action by the Indiana Supreme Court. Mr. Winneke attended law school at the IU McKinney School of Law, where he was president of the Environmental Law Society. While a law student, he interned for the Honorable John G. Baker of the Indiana Court of Appeals. After law school, he practiced civil rights litigation and also worked at the Indiana Court of Appeals as a law clerk for the Honorable Patricia Riley. Later, he worked in private practice in Greencastle, Indiana, where he was a part-time public defender for the Putnam Circuit Court. And there he handled major felony, juvenile delinquency, and child in need of services and termination of parental rights cases. Mr. Wieneke now maintains his primary office in Danville, Indiana, and accepts public defender cases by appointment in the Putnam Circuit and Superior Courts, Hendricks Superior Court 5, and from the Indiana State Public Defender's Office. Approximately 80% of his practice is criminal defense, and the majority of that work is as indigent counsel. He's a member of the Board of Directors for the Indiana Public Defender Council and the president of the Putnam County Bar Association. Ms. Wieneke handles direct appeals and post-conviction relief cases from all around the state. She graduated from the IU McKinney School of Law and began her legal career as a judicial law clerk for the Honorable Margaret G. Robb of the Court of Appeals of Indiana. She worked briefly as a family law attorney, but returned to the area of law she most enjoys, criminal defense. After working as a deputy state public defender, she opened her own firm. She has handled over 100 appeals and participated in numerous oral arguments before both the Indiana Supreme Court and the Court of Appeals. She co-authored a handbook on sex offender registration issues, and she is a life member of the National Association of Criminal Defense Lawyers and Scribes, the American Society of Legal Writers. Finally, Ms. Youngcourt graduated from the IU McKinney School of Law and began her legal career with the Indiana State Public Defender's Office in 1988, where she worked in the Capital Post-Conviction Unit. In 1992, she established a private criminal law practice in Indianapolis, while she also worked as a part-time major felony public defender for the Marion County Public Defender Agency. In her private practice, she has represented capital clients in counties throughout Indiana on a case-by-case appointment basis at trial, direct appeal, state post-conviction, and federal habeas petitions. In 2000, Ms. Youngcourt became a solo practitioner in the small town of Huron, Indiana, where she provided indigent trial and appellate representation in major felony and death penalty cases in southern Indiana. In 2010, she was appointed the Chief Public Defender of Lawrence County, Indiana, and tasked with creating an office and a system for the appointment of indigent counsel for a county of 45,000 citizens. Ms. Youngcourt has served on the Board of Directors of the Indiana Public Defender Council since 2001, as faculty at the National Criminal Defense College at Mercer Law School, and as faculty at the Indiana Trial Practice Institute. She also served as faculty at various death penalty institutes and trial skills programs. I personally have interned at the Lawrence County Public Defender Agency for almost a year now. She's my boss. It's been a great experience, and I would recommend that any student interested in working in public defense look at some of the opportunities available. I'd be happy to talk about it.
I can leave now. That's the real reason I was here, was to find my next round of interns.
So, where I'd like to start today is just by asking each of you to talk about where you see the state of the right to counsel in Indiana where you work today.
In Wayne County, Indiana, which is a county of 75,000, we are fortunate. Obviously, all felony cases, they're automatically appointed pauper counsel, almost whether they want it or not, and whether they're indigent or not, they get an attorney. Misdemeanor cases is always going to be an area where we turn and burn the cases a lot. If they show up at the initial hearing and say, I want to plead guilty, they're going to say, you can have an attorney, but they're going to keep moving. And that's, again, that issue of efficiency. If you appointed an attorney on every single misdemeanor case, you would need several dozen more misdemeanor attorneys just in our region. Juvenile counsel is an area where for juvenile delinquency law, Wayne County is one of the exceptions in the state that 100% of every juvenile delinquency cases in Wayne County gets an attorney, and I'm usually it. There are other counties where less than 20% of the children get appointed counsel. They all have the right to counsel, but they run through the rights quickly and say, do you want an attorney? And they go, no. And they just go against the prosecutor without knowing what is happening. We interviewed children that are at the Department of Corrections that were put there without ever having an attorney, and one we interviewed actually did a fact-finding hearing, which is a juvenile trial, by himself, and didn't know he could ask for evidence, was given no discovery, and just did the best he could, and that is a tragedy. So we have a right to counsel rule pending, early appointment of counsel rule pending with the Indiana Supreme Court, which would mandate that every child be appointed an attorney before they ever go in front of a judge to at least know what an attorney is before they waive it. And we also have the same issue statewide and in Wayne County with abuse and neglect cases, CHINS cases, where there is the right to counsel, but it's not an absolute right, and so many of the parents go unrepresented. They do have an absolute right to counsel in termination cases. So after the state has built their case for 2 years, where the parent is unrepresented going against the state, then when they file to terminate their rights, then they have the right to an attorney. So you go in and the state's file is this big that you get in discovery, and you hope for the best at that point because the state obviously is in a position of power. We would like that to change, but right now there is no U.S. Supreme Court mandate that at the abuse and neglect stage they have an attorney, and because of the cost, again, like with misdemeanor cases, often they don't.
Hi, I work in a Hendricks County and Putnam County, if you've heard. Hendricks County is a much larger metropolitan area than Putnam County, it being a donut county around Indianapolis. Most of the public defenders actually love their contracts in Hendricks County because the judges have some more money than in Putnam County to compensate them well with. However, it's in both counties, each public defender works directly for the judge and is kind of a servant to the judge, which naturally creates a conflict that sometimes gets in the way of the best litigation on behalf of the defendants. Sometimes it's hard to have the courage to step up to the judge and say, this is what we got to do. I know you're not going to like it, when your job depends upon you making that judge happy day in and day out. So I've seen several public defenders who it feels like a plea factory when you're seeing them go. But let's talk about Putnam County first. I was a contract public defender for Judge Headley in Putnam County for a year and a half before I decided to say, this is not working, I can't do this anymore, I feel too guilty about what's happening with my clients, I need to move on. The issues in Putnam County is there's a very strict restriction on the amount of money that the judges have in order to pay public defenders. There was a public defender agency there, but they did away with that in order to save money, took away their offices, gave each public defender an extra $5,000 a year, but took away all their benefits, took away their office, took away their support staff, and said, you run it on your own dime. And I don't know if you guys have ever run a law office before, but support staff, rent, computers, bar fees, all that other stuff is a little bit more than $5,000 a year. So when I was doing major felonies and the CHINS TPR stuff and juvenile delinquents, I was averaging about 200 clients a year for $35,000 a year. And that was all the way up. That included A felonies. I did get a little extra money on a homicide that I worked, which was, I was very grateful to get that extra money on the homicide. But the reality of the situation was I was fresh out of the Court of Appeals, only had ever litigated a case on my own, well, not even on my own, as a criminal defense, a criminal certified legal intern for the criminal defense clinic. And then I walk out of the Court of Appeals 3 years later, ready to start my own practice, and I get 34 new cases, which includes a homicide with a very good self-defense claim. So it was interesting, to say the least. So the reality is the money's not there. There's always an attorney who's willing to do the job for that amount of money, because somebody, needs to feed their family or do the work. And a lot of the attorneys that are willing to take the job for less than what it actually should be paying, they're not the type of attorneys who are going to say, Judge, I need money for an expert witness. The state's got 5 experts on their side, or they've got 5 detectives that have been working this case or something like that, and I don't even have an investigator. I need an extra $2,000 to have somebody go do all this criminal investigation for me. Most attorneys won't do that. I did that a few times and actually did butt heads with a judge on one case where we had an arson expert on the other side saying this was the cause of the fire, and I said, hey, I need to have somebody check this. My client's saying there's no way it could have happened. I wasn't even there, and whatever. It got all worked out. I think the state knew and understood that their expert wasn't really up to par once I got a report back from my expert, and so thankfully my client didn't have to even plead guilty to that crime. That was just completely dismissed. I don't know. That's it for right now. We'll let everybody else take over.
Well, I'm lucky in that the area of law that I'm in, I get to travel around the state a lot, so I get to see, and part of my job is to review what the trial attorney has already done and to see if there is any inadequacy. And so I see a lot of different things in different counties. I might see a really good defense, and I might see a really, really bad defense. And so I see where the inadequacies still are, and sometimes they're focused in certain areas in the state, and sometimes you have areas that are better than others. I think in my area of law, though, post-conviction, I think we have a pretty good setup in Indiana. We have better than other states, and so it's actually not that bad for getting counsel in that area of law, in that area of of criminal law. But some of the work that I see it's shocking. You can see, you talk about a plea mill. If some of these clients go to trial and they've maybe met with their attorney once or might have not even met with them at all, and it's just sort of they show up and, it looks, if the lawyer were asleep, you wouldn't have known the difference. And so sometimes I see really good work and sometimes it's really subpar. So I guess I have that advantage of getting to see a little bit of everything.
Ooh, I don't even know where to start. I got all these little notes I've written down. I have the perspective of seeing things from a couple of different angles. First would be individuals. I've represented lots and lots of public defender clients over the years. From the capital perspective, how the state chooses to spend funding for indigent defense, and then from a systemic standpoint, in that I created the system that provides public defense in Lawrence County. I would second something that Cara said, that we do have a great post-conviction system in the state of Indiana. It's incredibly well funded. So is our capital system. You get 2 lawyers, there's all these rules on how it's going to work. Does it make sense to put all this money after somebody's in prison and convicted and doing their time? Now we're going to look at their case? Does it make sense to wait for the guy who's been convicted of 3 or 4 prior felonies and now murders somebody? Does it make sense to spend $2 or $3 million of county funds, plus about the same in state funds, to put one man on death row? Those are big systemic problems. I think if you went back and you looked at Gideon, it's my recollection, Jim, stop me if I'm wrong, but I think that lawyer was unpaid. It used to be, and Indiana was one of the very first states that the Indiana Supreme Court found, based on the Indiana Constitution, that courts could not order lawyers to represent defendants in criminal cases. When Gideon was created, that's how indigent defense services were provided. If you had a law license, it was considered appropriate for you to go out and represent people in criminal cases. So it'd be sort of like your local doctor getting his medical degree and being told you only get to be a doctor if you treat, 100 people a year for free. Well, in many places, that's still how this system functions. And that's a systemic issue. That's not something that any individual particular lawyer can fix. The majority of public defenders that I've met and people that share our passion come from folks that either, one, they're warriors, they want to fight, and this is a hell of a good fight to take on. Two, they didn't get a law degree because they wanted to make money for somebody else. They didn't get a law degree so they could go help a bank make $1 million or help Jim Bob over there avoid having to pay, some settlement on a liability claim. They became lawyers because they wanted to help people. And thirdly, those people that are very interested in a system. How does a system work, and how can a system create things that are better for people? We're still struggling with that. When I teach at the law school in Macon, I teach lawyers who literally have caseloads of 500 clients. 500. They don't know their names. I mean, there's no way they can. So Gideon was a start, but it's never been completely implemented because it's never been funded. It's never really been adequately funded. Now, that all being said, I like to think in Lawrence County, this little system that we have, we're doing the best we can with what we've got. Indiana created a system in order to try and get qualified people with enough education and particular training in criminal law and caseloads where if you qualify in a local county that you can get reimbursed from the state about 40% of those expenses. If you get people in your local counties that understand how that works and can kind of figure out how to make that into a hammer to hammer people into doing what really needs to be done in order to get the full benefit of Gideon, you can create something that works pretty well. But I can tell you right now, even with the case standards, my lawyers have too many cases. I cannot represent these clients the way I did when I was in private practice.
Thank you. So something that I think a lot of y'all mentioned and a lot of people talk about regarding our contemporary criminal justice system generally is plea bargaining. And as was mentioned, across the United States, the vast majority of criminal charges end in plea bargains. And the Supreme Court has even issued some opinions in the last few years on ineffective assistance of counsel at the plea bargaining stage. And, where they even sort of say, look, this is how our system actually works. And my question is, can we have a functioning criminal justice system when it's a system of pleas rather than trials? And if we didn't, what could that even look like?
If we didn't have plea bargains,
Or a system based primarily on plea bargaining?
No system.
versus
There would
trial?
be no system.
The reality of how many criminal defendants get processed each day, each week through the system, the system would seize up, and it would not be effective anymore. I don't see how it would be possible for, going back to my county, Putnam County, there may be 4 or 5 jury trials a year. However, there's well over 1,000 convictions a year once you start throwing in misdemeanors and things. It couldn't happen. The state would have to hire a ton new there'd be new judges, new courts. Prosecutors' offices would blossom, blow up. They'd be huge. So no, that couldn't work.
And I think particularly now this war on drugs, it's really almost kind of a big game. Police are no longer out there responding to crimes. They are out there soliciting defendants to get other people to commit crimes. Confidential informants abound. So you get pulled over today on your way home and you've got an ounce of marijuana in your pocket. I can promise you the first thing the state cop who pulls you out of the car is going to ask you is, can you help me get somebody else? And so the police, the whole system is creating more and more and more defendants. And so I just second what Joel says, which is there's just no way. It would be absolutely impossible for this system to continue if everybody went to trial. The saddest part of it is, though, that it's very difficult for defendants to understand. So in Indiana, we don't have what's called Alfred pleas or best interest pleas. So if I have a defendant who's going to plead guilty, he literally has to go to court and say, I did X, Y, and Z. Well, many, many times the plea agreement that you're offered includes him pleading guilty to things that he didn't do, or he has a very hard time saying that he did because he didn't. So he's charged with 6 crimes and they want him to plead to 3, and he says, I did the 2, but I didn't do the 3rd. And then they don't understand why this system that is supposed to applaud honesty is telling them, if you want the deal, you have to lie. So the whole plea system is, it's very difficult. It's very ethically troublesome. That being said, it's also set up to get pleas. In many counties, you get arrested, and when you go to court the first time and actually have a lawyer present, which may be a week, 2 weeks, some courts a month down the road, you may still be in jail. And the plea offer you're going to get is, if you'll plead guilty to this, it's time served and you get to go home. And so then I'm in the position of telling my client, you can either wait for your jury trial, which is the quickest we're going to be able to get that is 70 days from the day that you're arrested. Of course, you will have lost your house. You will have lost your job. Your wife may leave by then. But we can get you a jury trial and you can prove that you're not guilty. Or today the judge is saying, or the prosecutor is saying, if you'll just plead guilty, say you did it, you can get out tomorrow or today. And then they wonder 3 years down the road when they've done that a couple of different times why they're habitual eligible. I mean, the stakes are huge, huge, but our system encourages guilty pleas to the extent, or actually to the detriment of most defendants.
Well, and I think we are required to tell the client we have a plea bargain and what it is, and the client has the sole power to say, I'm pleading guilty or not. That is one of the 3 things that are in their bucket they control. And so particularly if they're in jail, and I'm doing my job and saying, this stop is crap. There is a suppression issue that even the dimmest bulb is going to see. But that means we have to have a suppression hearing, which the judge will schedule at his pleasure, and then we'll be on the road if, you're going to sit here, though, unless you can make bond, and the bond is $25,000 cash, and
the
you're not
prosecutor
going
may
to.
pull the plea.
And the prosecutor may pull the plea if you could try to do the suppression hearing, because that's part of the game sometime. So the problem is when I go to them and I say, well, we have this huge legal issue. We could possibly make the case go away. These are the issues, and you explain it to them. Or you can just plead and get out. They're going to plead and get out. But when you pull the statistics that he's talking about, right, when you look at the public defense system, then you're like, well, you guys are turning and burning. You're not even doing your job. But part of our job is to advise them of the plea agreement, advise them of the issues of the case, and they get to decide whether to plead or not. And those cannot be stopped. That's the way the system works.
So I would agree. That's not a reflection on the public defender as much as that is a reflection upon the system.
Exactly.
And the system, Tom, you had.
I wonder if you'd explain, Lorinda, why the Indiana Supreme Court has not permitted Alfred pleas. It seems to me that could speed up their...
You would think so.
My understanding is that if you plead guilty, they want you to say, yes, I'm admitting to the elements of the crime that's charged.
What's their rationale for rejecting Alfred, which would actually complete some of their...
You read that case more recently than I have. I haven't read it in years, but anybody know? I'm a trial lawyer. I don't have to know the law. No, I'm just kidding. I don't know, because the federal system allows it. Many states allow it.
Would you explain what Alfred pleas are?
An Alfred plea would be you could go into court and say, I'm not going to say that I'm guilty or I'm innocent, but I will say that the state of Indiana has enough evidence that I could likely be found guilty. So you're really pleading nolo contendere. I'm not arguing against it. More than likely, Indiana doesn't like it because then they can't hammer you with it later when you plead guilty to something else and say there's your prior criminal history. But that's me being jaded.
In other words, I have no rationale.
There's not that I'm aware of. Not that I'm aware of, Tom.
Let me just speak in defense of that. Lots of people don't like Alfred pleas on the ground that a credible system of criminal justice should not be sending anybody away to be punished when they stand there in court and say, I am innocent of this offense, but I'm pleading guilty anyway.
I agree, but we have a system that... I hear you. I hear what you're saying.
Objection, and so states are divided on this. Some
Right.
states allow it, even the federal system, it's not like you have a right to an Alfred plea. The judge has discretion to permit you to do it or not. And some judges say, I don't like these kinds of pleas. It offends my sense of justice to watch somebody say, I am innocent, but please punish me anyway.
My favorite part is it doesn't offend their sense of justice that because he's got no money, he can sit in jail this entire time while he's waiting to decide, while some guy who's got 50 grand to post for his bond gets to get out. It's just a problem. It's a systemic problem. I don't know the answer, but it's a problem.
Out of curiosity, do you sometimes see prosecutors who will work with you and see that there is a questionable issue of law that needs to go in front and request the judge to lower the bond so that your client can get out and you can have that hearing without pressuring them?
I think I have the best prosecutors in the state of Indiana, quite honestly. I really do. They used to be defense attorneys. They're very open to lots of ideas, and oftentimes all I have to do is walk in the door and say, oh, this arrest smells, and they'll go, yeah, that really does smell. But then oftentimes what'll come out their mouth too is though, but this guy is a danger to our community, and I understand that this conviction, so I understand their position too. They've got a different scope of things that they're supposed to be looking at. But generally, yes, I'm going to let him out on bond because he has a suppression issue is not a conversation that takes place a lot. The conversation that takes place is because you've got this really good suppression issue, why don't we just plead to something a little less? So I've got a guy right now who the police come in his house. They just walk in the door, start going through all sorts of things. They end up arresting him on possession of some drugs, possession of a gun with drugs, all sorts of things. There's a clear suppression issue there, but he's going to sit in jail for a long time. I go to the prosecutor, and the prosecutor says, well, let's have him plead to maintaining a common nuisance. Well, technically, if we had the time to do all that suppression, he wouldn't need to plead guilty to anything. But we're going to take that deal. And we're going to agree to go to drug treatment and all kinds of stuff. But
On the opposite end of that spectrum, there's a county in Indiana that I deal with a little bit that part of my job is to call attorneys and say, hey, did you think about raising this issue? And on a suppression, for example, I called an attorney and I said, did you think about raising a suppression issue? It seems like a good one. Oh, the prosecutor pulled a plea. I'm like, he offered you an open plea to the lead charge, which means the judge can send you to anything. And
which is
said,
no agreement, no
agreement,
no
at all.
benefit.
Oh, but the prosecutor pulled pleas in other cases too, and I was like, okay. So that is a game that the prosecutors will play a lot, and I see it in a lot of counties. So.
Before we open up to any more questions, which we will do in just a minute, so in terms of broadly reforming our system of public defense, there have been a few sort of big ideas put forth. The first one I'd like to ask you all about is the idea of holistic public defense programs, such as the Bronx Defenders, where you have a public defender agency that's focused on more than just defending people, but is also about social work, social outreach. And I know a lot of agencies do this type of thing on smaller scales, but I'd like to hear any of your opinions on this sort of reform.
If I had a magic wand, which I don't, I wish we had paralegals, investigators, and social workers, because even though we're in law school And if you do this area of the law, you're going to understand that social workers, psychologists, understanding what in the heck is happening with the person, separate from the crime, is a big part of what we have to do often to find out how we ended up here as part of plea negotiations and stuff. That's a piece. And so I wish that we could do that. There's issues with going on a statewide system. Several states have done that. In order to try to deal with geographic disparity so that Marion County, which is flush with resources, gets something, which is Indianapolis. If my kid or my adult client gets arrested and processed in Marion County, they have access to different diversion programs and other specialty courts that are not available in the rural counties. And there's something just fundamentally gross about that, right? So if I trip over the line in Marion County and do X, but I follow the line in Hendricks County and do the exact same thing, I'm going to be treated completely differently because of resources. And so my wish would be that wherever you land in the state of Indiana, you're treated the same as far as resources. You might have a defense attorney that is not as well trained as another or whatever, and that's a separate issue, but at least as far as resources, everybody had access to the same.
Well, when you're dealing with, in counties where I work, contract PDs and PDs that are working at the judge's pleasure, they're not going to have
Right.
hardly any access to those types of resources through the public defender side. Now, their community processes or community things that they can tap into and refer clients to that can help. So it's not completely broken. And, you know, another good thing about working in a rural community is a lot of times the judges will know these families. And I've had clients where the judges will say, you know, I had their parents in court. I know why this kid in the juvenile is here in my juvenile court, or in, you know, this Chin's family is something happened generations ago that they, you know, they see the families, they know the families. I think in Putnam County there's less than 40,000 people in the entire county, so it's easy for them to have their finger on the pulse of the community, know what's appropriate for some of the people, and be able to make that distinction. So there's goods and bads, lack of resources, but maybe a little bit more personal understanding at times in the smaller communities.
Sometimes I feel like we're doing holistic. It's just we are the social workers,
Exactly.
counselors, psychologists, and lawyers, but
Yep.
that's just me.
I agree 100%. I think that there's almost two separate issues here. Well, there's several that we've discussed. One is, you know, this statewide system. Kentucky has a statewide system. I teach there. Missouri has a statewide system. I've taught there. The problem with a statewide system is it only takes one incredibly conservative legislative session for them to defund the entire process to the extent that public defenders have 300, 400, 500 cases. In a county-by-county system, each of us are out there fighting our own battles. I'm pretty happy with the fight that I've got going in my county and the resources that I have for what I consider to be my people in Lawrence County. From a funding standpoint, there's really two completely separate issues. And one thing I want to clarify is, as public defenders, we are as concerned, if not more concerned, about recidivism rates as prosecutors and police, right? Nothing breaks my heart more than the guy I've worked really hard for, gotten something worked out for him, to see him back in the jail. Okay, so that's one thing that we forget, is that we all really want our clients to get it, to get a hold of life and the American dream and get pulled up, right? But that takes not only funding for my office, but it takes community funding. I mean, right now, I forget what the latest number, 26% of the Indiana Department of Corrections inmates have mental illness problems. Do you know why that is? It's because we don't have any funding for the Department of Mental Health. Unless you come from an incredibly sophisticated family that knows how to go out and get services for your mentally ill cousin or sister, they are more than likely going to end up in jail because they can't conform their behavior to society norms. So without community funding for mental health, for addictions treatment, for parenting classes, for family mentors, juvenile mentors, without that community funding, we're all still fighting an uphill battle. You know, that's the big thing. House Bill 1006, which is supposed to be recodification of the Indiana Criminal Code. You know, the first goal or idea was that we were going to reduce the number of people in prison. You know, in 1977, we had 6,000 people in prison in Indiana. Today, we have 30,000 people. Do any of you guys feel safer? You know, we're all out of kilter. All out of kilter about where we're spending our money and where we should be spending our money and how we're going to really help people.
I would now like to open it up for questions. Professor Bell.
It is so fabulous to see so many public defenders here speaking passionately. I hope that you could say a couple of words about why you're public defenders. I ask this because I teach prosecutors and public defenders, and it's always easy to figure out why one would be a prosecutor. Public defenders, not so much. So it would be great if you could tell the students here why you guys are personally public defenders.
I interviewed a kid the other day in my office who happens to be here who told me, Brian, where are you interning now? And you told me you would be interested in a public defender job. Why? That'll teach him, won't it?
Well, I felt like there was a lot of injustice coming from a prosecutor, that they control the entire system, and there needs to be someone as a buffer between them, and I thought I could do that.
I mean, this is, I don't know how you want to put it. This is melodramatic, but it's God's work. You know, for those of you who are religious, but for the least of these, I mean, doesn't everybody deserve to have somebody stand by them in their darkest hour? And I am sure right now each one of you can sit here and think of 10 or 15 minutes in your life that you are ashamed of the way you acted, ashamed of what you did or what your behavior was. My job to stand by those people. Find them a way to get out of that if they can. If nothing else, just be that person that stands there with them.
I think, I don't know, I like the clients. Some of them not so much, but most of them I kind of like them in terms of hearing their stories. And, you know, every story is different how they got there. And so it's just interesting to get to know them a little bit. But I think I sort of like the challenge as well, because I almost never win. And so
That's not true. I can think
No,
of 4 or
I
5
almost
that
never
you've
do.
won recently.
But when I do, man, that feels good. And it doesn't even have to be me. We just had a big win last week in a case. Had nothing to do with it. But I felt good for 2 days. I was like, all right, this is why I do it. So we rode the backs of those attorneys for a couple of days and enjoyed. So that's why I do it.
Well, there's a lot of reasons why. I guess our whole democracy is based on protecting the individual and the individual rights, and so we're on the front lines. This is the essence of protecting the individual from the state. And not only that, but I guess the real reason why I feel gratified in doing this is I had a public defender once. I was a juvenile delinquent. I actually didn't really have any public defender when I was a juvenile. I got kicked out of the system without anything too consequential. But then some alcohol charges after that as a young teenager who was not really going the way that I should be going at that time. And I like to think that I still had redeeming qualities at that point in time in my life. And guess what? My clients, all of them I can think of, except for maybe one that I met not too long ago, seem to have redeeming qualities.
You'll find it. We always do. You'll find it.
I don't know. But yeah, it can be very fulfilling I like finding the silver lining in my client's story, presenting that to the prosecutor. A lot of my work is not battling out over legal issues with the prosecutor's office. A lot of it is sitting there and saying, finding the redeeming quality, talking to the prosecutor. This is what my client's been through. Here's their health conditions. This is why you shouldn't do this. This is why we should do this instead. And that really is what it's a lot about on the day in and day out.
For me, besides the whole standing in the middle of the client and the state issue, which is what I enjoy also, the teacher part of me likes the fact that I can help these clients understand what is happening to them. Many of them I keep track of the literacy rate self-reported of my clients. It's a question I ask in the interview. I would guess about 35% of my clients are illiterate. Certainly many are developmentally disabled, mentally ill, as Lorinda was mentioning. They have no idea what's happening. And I can fight the legal battles and understand the suppression issues and everything else, but they need somebody to stand next to them and say, this is what happens at this hearing. This is what is happening with your case. This is the legal issues. And the teacher part of this, so that when they decide to take a plea or not, when they decide to go down certain roads with the case or not, they are as informed as they can be given their limitations, that I can feel at least they understand what is happening to them. Because when they go unrepresented or are represented by somebody who's just like, give me $100 and I'll stand next to you and never talk to them, they do not understand what's happening. They will walk out of the courtroom and say, I don't know what just happened, and that should never be.
The system can roll over people, chew them up, and spit them out. That's the system we've made.
Yep.
This has been tremendously interesting, and I wanted to key in on this comment about the system and how it operates. Are there bad actors in the system that you think should be behaving differently? You mentioned prosecutors charging 6 things and offering a deal for 3 when your client only did 2. I'm curious, in that kind of situation, I guess 2 questions. One is, are the prosecutors behaving badly in that situation? Are they filing unsupported charges without probable cause? And then, separate from that, what do you tell your client in that situation? Do you advise your client to take the deal, or do you say, no, if you didn't do offense number 3, how do you advise a client when they're in that position?
First off, there's good actors and bad actors in every system. I think that the majority of prosecutors that I have dealt with in the last 25 years are merely doing the same thing that I'm doing, which is here's this system, here's this procedure, here's this process I've been tasked with, and here's all the ways, the tools that I have to get that done. I've come across some really bad actors, some bad actor judges, some bad actor prosecutors, some cheating prosecutors, some bad judges. Come across some really bad judges over the years. But that's not the problem with the system. The system itself, and I don't know the answer to it, the system itself is not functioning in the way that we teach kids in social studies that it's supposed to function. And so what I tell my clients, oftentimes, I was just teaching lawyers last week, and we were doing a session on attorney-client relationships, and this guy was really frustrated with his client because the client wouldn't understand that he had to take this deal. He should take this deal and plead to these 3 things, even though the one thing he hadn't done. And what the lawyer had skipped over, in my mind, was that the client thought it was unfair. I'm like, and that's okay. Guess what? I'm not the person who has to run around everywhere and tell you that the system is the best system in the whole wide world. It is okay for me to tell my client, this stinks. I know this stinks. Here's the reality of the situation. I hear what you're saying, but here's the reality. If you do this, this will happen. If you do this, that'll happen. And if you do this, we may have some options over here. But he has to decide. My job is to make sure that he or she knows the outcomes and the consequences of everything that's around there for him. I don't make those decisions for him. I run across lawyers sometimes who will say, I told that client, let's go to jury trial. I don't know that I have ever in 25 years told a client, you absolutely should go to jury trial. I'm not the one who's got to do the time. I get to go home and watch TV when I'm done.
I want to let the rest of y'all answer, but first, anyone who has class at 1:15 who needs to go, I promise I'd let you out at 12:55. Can y'all stick around for a few more minutes? Great.
Thank you for coming, those that are
Yes,
leaving.
Thank you.
And we take those internship applications all the time.
Okay, other thoughts on that question?
I think I want to piggyback on what Lorinda said. There are bad public defenders too. I've seen some people that I don't know if they started off with good intentions and they've just been worn out, but there's a point where if you feel like you're hitting burnout, you need to step and say, I got to pick another area of law, or take a step back. So there are some that I think are just going through the motions and don't really feel it at all, and aren't, they're the plea factory sometimes that we see. But I think something that Lorinda said I picked up on is sometimes the clients, they just want you to listen to them. I don't even care if what they're saying makes sense. They just want you to sit there and listen. And so sometimes I'll go to a prison facility and sit for 2 hours and let the guy just, and I'll write notes and I'll listen to him and talk back and forth. And sometimes that's literally all they wanted. Somebody to sit and talk to them and just listen to what they said, and then I'll leave and they'll write me a letter that says, I've never had anybody listen to what I said before, and then that's all they want. And if you can explain it to them in their terms so they understand, for some reason that's sometimes all they want. So.
Do you have anything?
Oh, on bad actors in the system?
Well, and his
Was
other
it just
question was about advising a client to plead to one that they're not guilty of. And my answer is always, you're going to be put under oath, and so we never set up something that you're going to lie to the judge. I wasn't there. Some people don't like this answer, but I'm going to tell you, I wasn't there. I don't know if you did it or not. But I'm telling you, you're going to be put under oath to tell the truth. If you take this plea, you're saying, I did X, Y, and Z, not just X and Y. And that's your decision, and it is their decision. And so to me, again, that teaching thing, right? I'm going to be put under oath where I could get in trouble, which won't happen, but it could get in trouble.
He's got prosecuting for perjury.
I
for
know, but
pleading
I'm
guilty.
saying, but they're going to be put under oath. They have to admit to all three, whether they did it or not, and it's their choice. And if they're in jail and can get out soon, they will plead out. And again, it's their choice, but the struggle I have is ethically under this perfect world scenario that we're all taught in law school. It should never happen. It is going to, if it's a choice between getting your kids back, keeping your house, they are going to plead and go. They're going to do it.
You would, and I learned quickly after I became a public defender that I wanted to take control of the factual basis
I did, yes,
portion of the
absolutely.
guilty plea hearing, so I could discuss with my client before we went in there, how can we make this work to where you're admitting to the crime, but you're
Telling the truth.
protecting your honor and your dignity and getting it out, because the prosecutor is, I had some bad experiences where the prosecutor was actually trying to beat up on my client during a factual basis, and I had to, make some comments on the record in court, and it's not something that should have been happening. My client was willing to admit that he was wrong.
Sometimes I like to use the opportunity to get more information.
Oh, yes.
They're, because they never get a defendant under oath, right? And so now they're under oath, and now it's who'd you buy it from, who'd you this, who'd you that, that sort of thing.
And I've also had clients that have asked me to sling some mud towards other people while they're pleading guilty.
Yeah.
Somebody who got a deal that
Yes.
probably shouldn't have gotten a deal the way it worked out in their mind.
Thank you. Any other
There's
questions?
one over here.
EJ.
Thanks for coming in. I guess, my concern is with this particular and rosy picture you painted of our system. It almost seems like if there's any hope for it, it's not even necessarily with the Public Defender's Agency, but with, the legislation in any given area to actually get the funding and the institutional support, because, you know, right now we have what's claimed to be an adversarial system, but only one side is really getting the support. And if that's the case, is there any hope, you know, even if you send your best and brightest to work as hard as they can, just under those limitations, it almost seems that without public outcry on the need for justice that is more equitable, that there's only so much you can do from your position.
I think
There's not going to be much public outcry, though, in general. At least I wouldn't anticipate it. You know, most people who haven't been through the system are very comfortable with what's going on right now. And it's a rude awakening for a lot of my families that have never been involved in the criminal justice system to see their husband go through a child molest charge, and they realize, oh my God, is this what it's really like?
That being said, I think that one of the best things, this is going to sound so peculiar, but one of the best things that has happened to criminal justice in a long time has been the downturn in the economy. You know, we grew from this 6,000 to 30,000 people in incarceration because legislators, it was very easy for them to be tough on crime and use that as an election platform. As time has gone on and the economy has gone bad and people suddenly wake up one day and they realize, hey, the number one line item on the Indiana budget is not education, it's not natural resources, it's the Department of Corrections. Then all of a sudden they look at it and they're like, well, is that really a good way to spend our money? So the downturn in the economy has sort of forced people to focus on, is this how we want to spend our money? If there's a way to continue to force that focus even after the economy recovers and the state has more money to spend, I think there's great promise for improvements. I mean, right now, even with House Bill 1006, it's not fully been funded, but there's all of this pour money into the communities for these local resources, and then let's treat people locally. So if you get a domestic violence case, and that family's going to stay together, let's get them treatment locally. Let's get them into family counseling. Let's deal with the children so maybe these children aren't going to grow up and become batterers or complaining witnesses or victims of battery themselves. So I'm not hopeless. I sound passionately hopeless, but I'm not hopeless. Because from the perspective that I am in now is kind of administrative plus doing cases, I'm also involved in a lot of the problem-solving courts, involved in trying to get community resources available, helping people get grants and different things. So I'm not giving up.
I think it goes back to the challenge too. If you win so few times, when you do, it feels great, and then it highlights the problem with the system. And that the Innocence Project has, in my opinion, highlighted so many problems with the system now. And they've only, in my opinion, scratched the surface. They only have so many resources. Could you imagine if we really threw resources at this, how many wrongful convictions we would have? So, to me, I think that highlights things as well.
Question.
Last question.
Ms. Winneke, I was curious, you said that you called attorneys to say, oh, did you try to suppress them?
They take my calls, yeah.
In fact, my question is about that. In fact, are you calling for like compliance purposes, for malpractice, to make sure they've actually done their job, or?
Well, what happens is after your trial, you then get an appeal, and let's say that you're not successful in appeal, our state allows for a process where you can challenge your conviction, and usually your argument is not, my conviction's not valid, your argument is the proceeding I was in was unfair. And so that could be because your lawyer, you had one, but he wasn't very good, or there's new evidence that's come to light since the new science, something like that. And so part of what I have to do is, or at least I try to, I call the lawyer to see, is there a strategy? For example, hearing that Joel likes to take the reins on factual basis. I was taught as in post-conviction, why would you ever be the one to plead your client guilty? Now hearing why you might do that, I think, oh, that makes sense. That's something I wouldn't know. But strategy, there may be a good reason why he said, I'll take him under oath and get the factual basis myself. And so that's sort of what I do. I ask them, well, did you think about this? Did you think about that? Because ultimately, if I go to a hearing, I have to call them as a witness as to why certain things happen. So I want to know what they're going to say before I go in there. And sometimes they have reasons. I mean, as much as I like my clients, I don't believe everything that they say, so I have to check it to make sure that they're not lying or remembering things incorrectly. I'll say it that way.
And from a procedural standpoint, the post-conviction system or the collateral appeal system has been created for the purposes of protecting convictions. Does that make sense? So it's like we gave you your bite at the apple, and now you're being this really pesky fly, and you're flying around and you're saying it wasn't fair, and the appellate courts are all going, get away, get away. The prosecutor's going, oh no, you got your bite at the apple, go away, go away. And so then they created this system where the only way you get relief is to make us fight against each other. Now, we do a really
that
good
is
job
true.
where we don't fight against each other. I'm more than willing to walk into court any day of the week and say, that was not my best day. Majority of lawyers aren't. So it's an ugly system created for the purposes of go away, go away. You got your 5 minutes. Hey, we gave you a lawyer that we paid $20 an hour for 10 hours to do your case. Now go away. Go do your time and go away.
Okay, thank you all for coming.
I just-